just wanted to let the public safety know what our vision is, what we are doing here in Marathon County. 2 weeks ago, we launched our first, I guess, pay it forward, and that was giving gift cards to the patrol officers in Marathon County, the entire county, to let them know how much we appreciate them, are thanking them for their service, and kind of start off the holiday season with thanking them. The group is continuing to try to raise money and to get the initiative going, and I guess one of our big slogans is catch the momentum, because we'd like the community to help show their support by reaching out to law enforcement on a regular basis on what they do for us, and we just want them to know how much they are appreciated. And we are through the, so we are a 501(c)(3). We're all volunteer based, so people can get information through the Community Foundation, and we are on Facebook where people can keep up with what. Sure.
So that's going to be the problem.
All right, go ahead, Kira. Oh, sorry about that.
No, it's okay. I was saying we are through the Community Foundation as a 501(c), so people can find information about the organization and the project on that website, and we have a Facebook page where we're keeping things updated so the community knows things that we are doing to for our officers in the community. If you guys have any questions.
Anyone have any questions for Kira? Dan, you want to go up?
There you go.
Okay, now the light's working. Oh, okay, thank you. Learning the technology. So I want to thank the committee for allowing our project to come before you and share a little bit of information. Kara just told you about the event that we just had and give you a little bit. I would like to share with you kind of the genesis and how this project got started, and give you an opportunity to ask any questions about us or what our visions or what we're attempting to do. This project, the genesis, I guess, started last June sometime when I happened to be at a convenience store buying myself a beverage at the soda fountain. And I was stepping up to the soda fountain just as a uniformed officer was stepping away, having just filled his cup. And the thought occurred to me that maybe it was obvious to me that he was there on a break. I had seen his squad parked in the parking lot, and he wasn't engaged with any customers or patrons or managers. So it just thought occurred to me that he was on his break, and here he was filling up his glass of pop. And the thought occurred to me that maybe what I should do is buy it for him, just as a gesture of gratitude and appreciation for what law enforcement does for us. So the officer and I didn't exchange any words. I don't know if we even had eye contact or acknowledged each other, but he was stepping away, and the thought occurred to me that I should pay for it for him, and so I just stepped to the cashier, and he stepped into the queue to come.
Excuse me. Excuse me, this is Schley. You're very hard to understand, and there seems to be some feedback coming in.
I'm sorry. Is that better?
Much better.
Okay, if it doesn't continue to be so, please feel free to interrupt. So so I stepped to the cashier, and I told the cashier when the officer comes up in the queue, this is to cover his beverage. And I went back to the soda fountain, was filling my cup, and the officer came over and thanked me for the gesture, and that was the extent of our engagement. And I got back out into my car, and I thought, I don't think that that happens in the community probably as often as it should. And that thought stuck with me for a few days, and I went and shared it with a good friend of mine, and essentially that's what spawned this project. We got to talking, and we said, you know, maybe we could do something. Maybe we could get the community engaged and raise some funds to communicate to the law enforcement community throughout the county that the community is behind them. So that's the genesis. That started in June. I learned very quickly after contacting Sheriff Parks and talking with a couple other chiefs around the area with Chief Bliven and the chief down in Everest Metro that technically what I did was a breach of protocol, that the officer was not supposed to accept a gift. And I never gave him an opportunity to refuse it. I paid for it before he was up to the front of the queue. And so that bothered me a little bit. And so I have two messages, I guess, for this committee. Number one, we took a couple months in organizing ourselves, and working with Sheriff Parks has been very, very helpful in helping us navigate, through these protocols, et cetera. We went through a vetting process with the Community Foundation and became affiliated with them, which gave us the 501c3 status, so that members of the community who wish to donate and support this cause can do so on a tax-deductible basis. And my first message to you is that when we got our act together and started raising funds, it was extremely gratifying to myself and other members of the committee how enthusiastic our idea was throughout the community. And the message that I would like to share with this committee and have you share with any members of law enforcement is that the community is very much behind our local law enforcement. I've got a background, I'm a retired instructor from North Central Technical College, but I've got a background of serving in community service organizations as a young man, the JCs, a little bit later in my career with the Kiwanis, and in a number of other organizations, and I've worked on community service type of organizations. Never in my life have I found it so easy to approach members of the community, ask for a donation, ask for funds, and have them open their checkbooks. And so that is my main message. My second message is that it occurred to me after finding out that what I did was essentially a breach of protocol. I gave that a considerable amount of thought, and I fully understand why law enforcement has to maintain a perception of integrity and that they can't be seen as accepting gifts, et cetera. But as I thought about that more, I thought, that really is a breakdown in the humanness or the symbiotic relationship that takes place between any two individuals. That if you think about it on a personal level, you have friends, family members, spouses, and that relationship that you have, even if they're only casual friends, there's a certain symbiotic relationship. And if you are precluded from your half of the symbiotic relationship, in other words, you can't do a nice gesture for the other partner, that breaks down that connection, if you will. And I just wanted to raise that as a red flag, if you will. I certainly understand the need for the policy, but I want to alert you that there is a cost. There is a cost. And I hope that our project can somehow alleviate that cost and offset that cost. But I am not, I'm a civilian. I'm not a member of law enforcement, never have been, have never had any extensive contact or experience working with law enforcement. But I appreciate what law enforcement does, keeping our communities safe, and I can only imagine the difficulty that is presented on a morale basis to law enforcement officers and all personnel for that matter, even behind the desk. on a daily basis in trying to serve and protect when much of the news and much of the community is deriding them and criticizing them and only finding fault. So it's been my honor to help bring this project to fruition. We are planning to do this on a continuous basis. Our initial presentation on November 19th was the first of what we hope to be many. It was actually the second. We did do a pilot or a trial run with the Everest Metro. We thought we would try and crawl before we walked. And when we found out that there were somewhere in the neighborhood of 250 uniformed officers throughout the county, we thought, well, maybe we ought to try this on a little bit smaller scale first. So sometime in the month of October, or maybe it was late September, we did a trial run with just the Everest Metro department because that was a little smaller scale. But it's been very gratifying in working with this. We are a completely volunteer organization. None of us are paid. We are still recruiting members of our steering committee. We've got maybe half a dozen to 10 maybe individuals. We've been meeting about once every 2 weeks. We are now planning our next event for sometime in early January, which is National Law Enforcement Appreciation. And we hope to do something then, and then another month or a month and a half after that. But we are completely revenue-driven. We will continue to do and as much as we can based on the revenue that we can generate from the community. Based on what we've experienced so far in the little bit of personal contacts and arm twisting that individual members of our steering committee have done, we've found it quite easy for people to open their checkbooks. And so that concludes my remarks, but again, I want to thank you for the opportunity. I'd be happy to answer any questions, and I have some fundraising brochures here that I'd like to share with you and have you, members of the committee, if it's all right with the chair, members of the committee or anyone here any members of the public, that if you want to share these with friends and whatever.
You can hand them out. I can put them in the mailboxes. Okay.
So I'd be happy to take any questions if anyone has any. Yeah.
If the citizens or any individual wants to get involved, is there a contact person that they
The contact information is in this brochure. Thank you. Yeah, thank you. We do have a Facebook page, as Kara had mentioned. You can find us under Law Enforcement Appreciation on Facebook. We are also listed with the Community Foundation. So if anyone wanted to go to the Community Foundation, you have to click on a few things to get that. That would be a process for donating. For donating online. If an individual did not wish to donate online and would just like to send a check, they can do that by mailing it to Law Enforcement Appreciation Project, or we're using the acronym LEAP, L-E-A-P, at P.O. Box 1991, Wausau 54402. So, and our contact information is also available on the Facebook page. So thank you very much for that suggestion. Any other questions? Thank you, committee members. Thank you, Charlie.
Kara, did you want to add anything else?
I think Dan did covering how the program started, and if anybody does have any questions in the county, they can reach out to me.
Mr. Chairman,
Go ahead.
can they place one of those in our boxes?
They are going to, yes.
Oh, okay, I missed that. Thanks.
All right, we're going to move on to A, policy issue discussion and committee determination to the county board for consideration. It's also under operation functions required by statute, ordinance, or resolution. Scott, I assume you're gonna have either Chad or who else? Okay, so go ahead, Chad.
Just getting this pulled up here. So this is the proposed ordinances, I believe. That's where we're at, right?
Yeah.
That was Sean McCarthy was handling that, but I believe that Mike Purner is on, and he is the one who is addressing those.
That's correct. I am here, Chair Boots, if you would like me to give a little bit of background.
Yeah, go ahead.
You bet. So, as the committee's aware, Chapter 9 of the General Code of Ordinances is the chapter that addresses public peace and good order, and there are currently 20 separate ordinances in that section that deal with various offenses that the Sheriff's Office can issue citations for. I was approached by Captain Sean McCarthy from the Sheriff's Office some time ago to discuss whether expanding this section might be helpful to the Sheriff's Office. So the goal in our discussion was not to expand, I guess, the amount of offenses that are prosecuted, but instead to enhance the toolkit for officers when they're in the field. When I met with Captain McCarthy and Lieutenant DeNovi on the issue, we came up with a few suggested changes. And from there, I went forward and also changed the formatting for this chapter to make it a little bit easier for the public and for officers to review. So in your packet, there is a version of the new proposed ordinances that has the proposed changes outlined with an explanation. I can go through them pretty quickly, and then if people have questions for either myself or Captain McCarthy as far as the policy behind things, that would be fine. First of all, the chapter would start with kind of a general scope, authority, and penalties section that makes things a little bit easier to read and defines the scope of the entire chapter for people to understand. Part 1 adds 2 additional county ordinances, one for battery and one for harassment. Those mirror state statutes that discuss the exact offenses, and what this would do would be to allow sheriff's deputies who are in the field to be able to use their discretion and determine whether a citation may be more appropriate to issue in a particular case. I should note, before presenting these to the committee, we also had a conversation with District Attorney Whetstone and her office about whether or not they would be in favor of these changes. And I know Teresa is on and she can speak to this if she wishes to do so, but I can just share that we had a good conversation about that, and my understanding is their office would be supportive of these changes as well. Most of the changes here are renumbering or some additions. When you're moving to Part 2, the disorderly conduct sections were already in existence. Resisting or obstructing an officer was added. That was something that Captain McCarthy and Lieutenant DeNovi had emphasized as far as there is some conduct that would fall within this criminal statute, but perhaps officers would like some additional discretion in the case that an ordinance would be more appropriate to be able to issue that. Part 3 contains offenses against property, and the damage to property and theft ordinances would be new. They again mirror the state statutes that prohibit the same conduct and create criminal penalties for it. The retail theft section is already in the current code, as is the issuing of worthless checks. The trespass section is new and it mirrors the state statute regarding trespass. Abandoned vehicle is a entirely new provision. Was created when we consulted with the sheriff's office about a potential issue with abandoned vehicles being left in private lots and how the department could best respond to that. So this would give them an additional tool to be able to do that. Moving 4, the violation of alcohol beverage laws is currently in existence. There are no changes there. The minor pornography section was already in the code, so that is not changed. The truancy code, the only part of that section that changed is subsection 5, which adds the ability for deputies to issue a citation for contributing to truancy. And that would be if a parent is encouraging or contributing to the child's truancy. That would just give, again, some extra enforcement options in the field. Moving down to section 9.45, the only change in that section is to add nicotine products in addition to cigarettes and tobacco products. The reason for this is, number one, the state statute was updated with that language, so this update now mirrors the statute. Additionally, it would allow deputies to address vaping and the use of vape pens by underage individuals. Section 9.51 hasn't changed. 9.52 is a pretty simple littering section. 9.53, an unauthorized dumping section. These came from requests from deputies in the field based on things that they had experienced. Section 9.54 would codify a prohibition of dangerous items in the courthouse. And it's written so that if a person is made aware of the prohibited nature of the item and brings it beyond the security checkpoint, they could be subject to a citation for violating that section. Corporation Counsel Corbett and I wanted to make sure the language was written in a way that provided the person who could be subject to it notice of what they might be violating, but would also give our security officers at the checkpoint the ability to have discretion in determining what is dangerous. Section 9.61 was requested by the sheriff's office and really mirrors section 101.123 of the statutes. It's directed at people who are in charge of a particular establishment and allow smoking at the location. So instead of having to issue a state forfeiture, it could be addressed through a county citation. That is similar to a change that we'll talk about later. 9.63 is again a simple change in that section that adds nicotine products, and that's again based upon the state statute changing. It's also based upon the sheriff's office requesting some additional ability to deal with those vape pens and products. Then moving down to 9.64, that section would allow sheriff's deputies to issue citations if patrons are on the premises of a tavern after closing hours. There is currently a state law that prohibits this, and right now deputies are kind of stuck with issuing those state charges. This would provide a separate county ordinance option instead of having to go with a state charge. Section 9.71, there is currently a possession of marijuana and drug paraphernalia section. This combines those and adds synthetic cannabinoids as well. And the remaining 3 are already in the code, so there are no changes there. As I said, the idea behind these changes was to give sheriff's deputies some additional tools in their enforcement ability. And Captain McCarthy, I think, can talk to that further if the committee has any questions about it. If there are any questions about the language or the drafting, I'd be happy to answer those. And as I indicated, District Attorney Whetstone and I have had conversations about this as well, and I believe her office is supportive of the proposed changes.
I really don't have much to add. I know that Captain McCarthy was leading this initiative, and that what really spurred it was a number of things, but providing options for patrol deputies to do things more in line with diversion. It's an option to take enforcement action without bringing someone to jail. So this is that one of those enhanced tools that we will now have by having these ordinances updated. That's basically the crux of it.
Okay, any questions by anyone in the committee for either Mike or Chad? Go ahead, Chair Gibbs.
Do we have any idea how many cases this may or may not potentially allow to be diverted?
I don't have an idea of what that would be. I think that until we actually get into using it and seeing what that will be the true test.
This is Supervisor Mask.
Supervisor Mask, go ahead.
It's nothing to do with the ordinance, but there are people that are not muted, and we're getting a lot of feedback and echoing, and it's getting harder and harder to understand people.
All right, in the future, I'll have them come right up to the front podium. It seems to be a little better.
There are people who are on that are not muted, and I think that's creating the problem.
All right, could you please, if you are calling in, mute your phones if you are not on saying something? All right. Any further questions for either Chad or Mike? All right, if not, you all have the resolution in front of you to amend Chapter 9 of the General Code of Ordinance relating to regulations relevant to public peace and good order within Marathon County. Do I have some sort of motion?
Make that motion, Supervisor Mask.
Supervisor Mask with a motion. Do I have a second?
Lamont.
Lamont Jacobson, or Bruce Lamont with a second. All in favor?
Aye.
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 Any opposed? All right, passes. Educational presentation outcome monitoring reports. Thanks, Mike, and thanks, Chad. Educational
welcome.
presentations, outcome monitoring reports, diversion programs. What are they? Who do they serve, and how do they impact our justice system? I have Ruth gonna take a. Go ahead, Ruth.
Actually, if it's okay, Chair Buick, I was going to do an introduction to it a little bit before Ruth starts speaking.
Sure, go ahead.
Okay, thank you. I appreciate that we're following the presentation on the ordinances because as Chief Deputy Phillip alluded to, that's a mechanism of diversion. And we did have discussions about that, and the ordinances, it's the District Attorney's Office responsibility for prosecution of county ordinances. So one of the things that will allow us to do also is have some oversight of those ordinances and when they're issued. And we're going to talk through a little bit about, those ordinances would be put onto CCAP. Those ordinance violations would be put onto Wisconsin Circuit Court Access. So it would be seen by the public. If you had a similar situation at the Wausau Police Department or somewhere, some other municipality, it would not be readily apparent to the public that you had that ordinance violation. So it is a wonderful tool to have for law enforcement, but it also isn't the end of the story. There may be times when we, pursuant to Marcy's Law, which is the new constitutional amendment for victims, we would want to take a different approach from that ordinance. We might want to offer a diversion to the defendant through our diversion program that would keep that off of CCAP, off of Wisconsin Circuit Court access. So even though it's not a criminal violation, we would take the opportunity to have it not appear anywhere publicly because that could be detrimental to the offender down the road for jobs and so on and so forth. So it's a kind of a nice lead-in that the checks and balances kind of nature of the criminal justice system and all the different dynamics that come into play. So the diversion, I appreciate the opportunity to talk about our diversion program in Marathon County. The diversion program is a non-mandatory program. So in many respects, what the district attorney's office does is sort of mandated by statute, but the diversion program is not mandated by statute. There are a limited number of programs throughout the state and in the counties throughout the state because it's really a decision that rests with the district attorney's office. The decision whether to issue criminal charges in any case in the county, in the state is solely within the discretion of the district attorney for the county in which the crime occurred. It is also the district attorney's office sole responsibility to prosecute criminal cases in the county. So the concept of diversion is to divert cases away from the formal criminal justice system. The decision whether to divert instead of charge a criminal case that's sent to the district attorney's office is solely at the discretion of the district attorney's office. So as the district attorney, I'm to administer justice, and I believe that justice must be individualized and must always take into consideration, first and foremost, public safety, then victims' rights as well, and harm reduction. If a program is run based on evidence-based principles with goals of reducing recidivism and increasing restoration of victims, and the outcome measures of that program are monitored, the end result will also include cost savings by offenders not having new criminal offenses and case processing cost savings by not having the cases come into the formal criminal justice system. But those are end results of a well-run program. They don't drive the program. What drives the program is public safety, victims' rights, and harm reduction. And the word recidivism, because this is an educational presentation, it's important to understand the word recidivism. You'll hear that a lot. It's used in a lot of programs, but it's important to understand that it can be used to mean a lot of different things. It's important to know what it means when you're looking at outcome measures of a program. Does it mean recidivism by another arrest? Does it mean recidivism by new criminal charges? Those are two different things. Does it mean a period of time of 1 year, or does it mean what period of time are you looking at? All those things can affect the rate of recidivism. So in order to determine if there has been a positive impact on the offenders by the program, and whether the program is improving public safety by reducing the number of repeat offenders, the program's recidivism rate must be compared against the rate of repeat offenders similarly situated without the program. So is the program making a difference? Or are we not really changing the recidivism rate at all? If the rate, for example, of people who are repeat offenders without the program is 20%. 20% go out and commit other crimes. And the rate with it is 25% with the program that commit other crimes. What's the issue? Are we putting the wrong people in the program? Is it a bad program? Different criteria is being used to calculate recidivism. It could be all kinds of different things. So data doesn't tell the whole story. And I gotta say, there always will be some sort of anecdote that someone will share that pulls at people's heartstrings and just makes you wanna support the program. But as a district attorney, I have to look at data because it does tell a more complete story about the whole program, the program as a whole. And it's essential that our diversion program, that we select offenders whose actions, if criminally charged, could be proven beyond a reasonable doubt. That's one of the reasons why we have the prosecutor involved in the initial evaluation of the case. Second, the prosecutor must review the criminal history to ensure that the offenders are appropriate for the program and there's no obvious public safety concern based on the criminal history or the charge. Third, if there's a victim, the impact on diversion on the victim financially and psychologically must be considered. And finally, there must be a check on the decision to divert by the attorney. Just like we were talking, a check on the county ordinance, there is also a check on our attorney's decision to divert. And this is done by a professional with specialized training, and this is our diversion coordinator and our diversion specialist. So they also then assist in tailoring individualized programming needs for that offender. Like I said, individualized justice to have the most impact. And then this is sort of a second tier screening by the diversion coordinator and specialist, which is essential to the program's success. So our diversion coordinator and specialist could kick that back to the attorney and say, based on what I'm seeing here, this is not appropriate for the integrity of our program. We're not going to move forward, or we suggest you not move forward. So that's a big introduction for Ruth Heinzel, who is our diversion coordinator. And I hope that was a little bit of some foundation for you.
Good afternoon, everyone. This is a lot of information. I'll go over it quickly. It won't take too long. But if you have any questions, please interrupt and ask them. I've been working in the diversion program for 10 years, so sometimes I don't know if you don't know something. So to begin, to me, the purpose of diversion is to give alternative options to the normal criminal justice process so we can treat people as individuals instead of cohorts with, pre-assuming that everybody did the same type of crime like you would going through the normal court process. So I guess to kind of get us in the mind of what it looks like, I was going to talk about a story, or I guess an actual real event, and then you guys can reference that a little better throughout the talk. So in July 2017, Adam and his girlfriend Sarah, they traveled south on 51 from the Northwoods, and they lived in Illinois. So of course, going home to Illinois from the Northwoods is a long drive, and so they were going 76 miles an hour, which isn't speeding too much. But once they got to Brokaw area, they entered a construction zone and decided not to slow down. So unbeknownst to them, there was a state trooper sitting on the on-ramp monitoring speeding, and the trooper pulls them over. So the trooper goes up to the car and notices that Adam is shaking. I mean, most people would be pretty nervous in that situation, but he also smells marijuana. So he tells Adam and Sarah that, hey, if you're honest with me, I will give you a citation to appear in court instead of arresting you today. So Adam and Sarah say, well, we have a marijuana joint in our car. We just don't know where it is. So the trooper asks them to get out of the car, pats them down for weapons. Then he searches the car and finds marijuana edibles and some marijuana paraphernalia. And he confronts the defendants, asking them why they didn't tell him the truth. And Adam's like, oh, I thought you were just asking about marijuana, not paraphernalia. So the trooper decides, uses his discretion, saying that, well, they weren't honest with me. So he arrested both Adam and Sarah. So at this point, Adam and Sarah get booked into jail, sign a signature bond to appear to court, and they go back to Illinois. So they don't stay in jail. They just get booked in, like fingerprints, photographs, sign the document, and then they can leave right away without paying money or anything like that. They just have to sign a form saying they'll show back to court. And then the trooper goes back and he writes the report, and then that gets sent to the district attorney's office for review with any kind of digital video or anything like that. So the assigned assistant district attorney reviews that report, and then they use their discretion on whether or not to charge. So in this case, the assistant district attorney decided not to charge both Adam and Sarah because they did not have a criminal history. Now, typical situations with possession of THC, I kind of start out with a basis of individuals that are younger with marijuana charges. Usually we have them go to Attic Correctional Services for case management and do drug testing, and then get an alcohol and drug course. Well, since they live in Illinois, they did not qualify for Attic Correctional Services since they only deal with county residents. So my choice at that time was either to send them back to the assistant district attorney for charging, or I could monitor the case myself. So I thought to myself that it wasn't really cost effective for the county to if we charged the cases, and it would also be detrimental to Adam and Sarah if we charged the cases. So I decided instead of having them go to Attic, I would have them do an online education course and reduce the time period that they were under a diversion agreement. So I contacted Adam and Sarah by phone so they didn't have to drive up from Illinois to just show up to court, to realize that they actually didn't need to show because we were going to offer them an alternative offer. And I go through the paperwork with them and find out while I was talking to them that they were both in college and very thankful for the offer, because if they were convicted of the crime, they wouldn't be able to get student loans and they wouldn't be able to go to school anymore. So I guess that kind of walks you through that process. They both completed the online course, turned it in to me, and then their case was closed, no prosecution. So in the packet, I have, I put in two different kind of infograph type things. One of them is opportunities in the criminal justice system, to kind of pull it apart a little bit. So the way that, like I said earlier, you can make sure to individualize things is when people are given discretion, right? So there actually are four main areas where discretion is used. One of them is when the judge makes a bond decision, and that's not on here because that's not considered diversion. That's just part of the regular criminal justice process. So the first point where you can, where someone can make a decision on whether or not the person continues through the normal process would be with law enforcement on whether or not to arrest. So the Sheriff's Department and other law enforcement agencies in Marathon County actually have a lot of really good diversion alternatives. Two of the major ones that have started in the last few years, one is the crisis intervention team, which they will respond to mental health crisis usually and try to de-escalate the situation or take the person to treatment instead of jail. And then the other one that they use is the proxy program, and the purpose of that one is to be able to help them decide whether or not to issue a citation. Like in the incident that I walked you through, he was giving them the option of giving him a citation instead of arresting them. And that can happen in many instances. Things they wouldn't use that for is if there was a bond condition needed, like a no contact, or a lot of felonies are automatic arrests, depending what they are. And each agency has their own policy and way that they handle those things. So then the second major decision point is at the prosecutor's office and deciding whether or not to charge a case. So we have a pre-charge diversion program in Marathon County, which is very uncommon. It's becoming more common, but not a lot of counties in Wisconsin have a pre-charge diversion program. So defendants are pretty lucky to have this option because it does keep your record cleaner. So when talking about a record, there are 3 different steps that show up on a record. So first, you don't have a criminal record if your fingerprints are not taken. So if Adam and Sarah were not arrested, they wouldn't have any record at all. But since they were arrested, they were fingerprinted. And once you're fingerprinted, it goes into a database where you officially have a criminal record. And the charges that you were arrested for are the charges that appear on there. So if you apply for a job or an internship, it will automatically say, your background check would say charges, marijuana, and then some background checks don't really give you much more information and some do, depending what system the people use. So the other 2 things that show up on a background check are the charging. So if they were charged with a different crime or they weren't charged at all, that will show up on a background check. And then if they were convicted, will also show up on the background check. But it does not become public until the charging point. So Teresa talked about CCAP, and that's where anybody in anywhere in the world really could look up your record in Wisconsin and see that you were arrested for, or you have a criminal case, so you were charged with a crime of some sort. So with Marathon County, with citations as well, even though it's not criminal, that stuff shows up on CCAP, and people can be discriminated against that even if they're not supposed to be. So there are a lot of benefits to diverting people prior to charging. If you divert them prior to charging, they don't touch the criminal justice system. So it saves a lot of time and really eliminates them touching like the clerk of court's office, and the judge never sees them. The prosecutor just has to deal with them for the initial overview of their cases. So it can be really helpful for the system and declogging it a lot if they're diverted at that point. So the next decision point, I guess, where someone could be diverted is the prosecutor, another prosecutor one where they do plea negotiations. So they could do a typical plea. Like when you're giving your criminal complaint, it tells you like the maximum penalty you could get in a certain case. And the prosecutor could have typical, sentencing recommendations that they have for certain types of charges and stuff like that. But they could also, in Marathon County, luckily, we have the option for post-charge diversion programs, which is very similar to pre-charge. There's not a lot of difference. It's just the person's charged. So then they're on bond as well, which can be helpful for victims. And it is something that we consider a lot, like Teresa was talking about, where sometimes victims need that kind of safety where the person needs to be on bond. So for a lot of post-charge diversion, we do first-time domestic offenders, where they go to the SAFE program, which is a domestic program through Peaceful Solutions Counseling, and they get counseling. Then we either reduce the charge to a citation level charge, or we dismiss it altogether if they are successful. So if they're not successful, they're convicted of the charge, and then they will be sentenced accordingly, either probation or jail. Any questions so far? I have some data on there to kind of help you see what effect that diversion has on the system. So I've been working inside the district attorney's office for 5 years. 5 years prior to that, I was a case manager at Attic Correctional Services. So this is data since I started in the program. The top number is the average number of active cases. The total referrals is the next, and so on and so forth. So we successfully diverted over 1,501 defendants in the last 5 years. The program has been around since 2007. We do have one of the largest diversion programs in the state, close to where Dane County and Milwaukee County is, a lot larger than Eau Claire and Outagamie. Then we also collect restitution for victims. That's one of the most beneficial things I think for victims, is that they get restitution sooner in many cases. So instead of having to go through the whole court process, which usually averages about 120 days or so, instead of waiting that 4 months, they can get the money a lot sooner than that, whenever the person agrees to the agreement, I guess. Another thing that's beneficial for victims is that a lot of times, if it's family involved, they just really want the person to get treatment. They don't want them to become a criminal, and it gives us the opportunity to go along with that. So the next lower down, I guess, is the diversion recidivism. So the national recidivism rate is 33%. There's been a lot of different studies, and that's typically where almost every study I've seen, recidivism falls at the 33% line. For deferred prosecution agreements, which is our pre-charge program, that's the teal color, and then our post-charge program is like the navy color. So there could be a lot of reasons why post-charge diversion has a higher rate than pre-charge, but that could be like an hour conversation. So if people have more questions about that, we can go on that as well. But I think that's all I really have for today, if anybody has questions.
Any questions for Ruth?
We just really appreciate the opportunity to provide this information to the committee. And hopefully, maybe as you think about it or review this information or think about this information, it'll spur more questions, and we love questions. So if you want more information or have more questions, and they don't come to you right now and they come to you later, please feel free to reach out to Ruth or I at any point in time. Be happy to give you more in-depth information, or if there's particular data or anything you're looking for, please reach out.
All right, thank you. All right, then we will go to 6C, update on our evidence-based decision-making, pretrial assessment, and case management planning and pilot.
Let me out of here, just for a second. Thank you, Chair Boots, and we have Laura Yari kind of here to give a presentation, and I'll echo what Teresa just said with, it's nice that we're building on, the first presentation from Mike Pierner and Chad, and that led into the diversion discussion. This discussion that Laura's going to have is, building on what Ruth talked about. You saw what the informal, non-traditional criminal justice system looks like through the DPA, or deferred prosecution, the pre-charge diversion component. She also referenced the utilization of a deferred entry of judgment, or a post-charge diversion strategy, where there's benefits of an individual being on bond. So Laura's going to talk about a program that our evidence-based decision-making group has been discussing for some time. Really, this has been a lead project, a project, I should say, that Laura's been leading through working with the state of Wisconsin for some time, quite a number of years actually, with our evidence-based decision-making group, and that is our pretrial case assessment and management. So with that, I will turn it over to Laura. I'm going to attempt to share the screen again. I hope that's been working during the last couple of presentations, but I'll attempt to share the screen because in your packet, Laura had a couple of pieces of information. So with that, I'll introduce our Justice Alternatives Coordinator, Laura Yari.
Hello. I think that whoever put the agenda together did a really nice job of putting things in order. Ruth talked about decision points in her presentation, and that is really what started all of this discussion about the pretrial program. We started working with the National Institute of Corrections and the Wisconsin Department of Justice 5 or more years ago, looking at all the decision points within the criminal justice system. And as Ruth mentioned, we have a very robust diversion program and lots of options for diversion and individualizing that process for people coming through the system. The diversion, the DPA, and the deferred entry of judgment has actually been around in the Marathon County DA's office since 1997. In 2007, the coordinator position was added into the district attorney's office so that we could expand the number of people that were being diverted as well as the types of offenses and looking at some additional people with higher risks and need levels. And at that time, we also expanded case management through our contract with Attic Correctional Services. So our pretrial identified, our work group identified the decision-making point where a judge determines whether somebody is released into the community while awaiting for court process to take place and additional hearings. And it's a very important decision because obviously it can affect somebody's entire life, their job, their family, their freedom. And so it's a decision that holds a lot of weight as to making a good decision. And we identified very quickly in our pilot group, which there are 7 other counties that we're working with on this, that none of the counties were doing any type of evidence-based assessment to help inform the judge using an actuarial tool. So the research that we studied through the National Institute of Corrections, of course, showed very clearly that when professional judgment is enhanced with an actual assessment tool, outcomes are much better. So we were selected as one of the 7 counties to start a very large planning and pilot process. And quite honestly, we had no idea how large of a project this was when we started it. It sounded pretty simple. We need a tool. We should select a tool. We get trained in the tool and we start using the tool. Well, that was somewhat complicated because we had to work with 7 other counties from different parts of the state and many different agencies. And we picked a tool called the Public Safety Assessment that was a brand new tool that had a lot of research behind it, but it had just been made available for public use. So up until that point, you could only use it if you were in the research study through the Arnold Foundation that created the tool. So once we selected our tool, we started on a very long planning process. So all of the coordinating counties, the Department of Justice staff with National Institute of Corrections staff and funding, we selected the PSA assessment. It measures 2 things that a judge is supposed to be considering when they're making bond decisions, and that is the likelihood that the person in front of them will appear for future court appearances, and public safety. How likely are they to commit new criminal activity while they're awaiting court appearances? So once we selected the public safety assessment, that brought in the Arnold Foundation, and they gave us a lot of guidance on the tool. And basically, we signed an agreement that if we use their tool, we will follow their research suggestions and follow implementation and follow all of the guidelines that they wanted followed in their research study. So at that point, we started working with them to develop very detailed policies, procedures, and an operational guide, as well as an operational agreement of what data would be collected. And this, the Wisconsin Department of Justice wanted to be consistent among the counties, because the goal of this was for the 7 counties to begin this pilot, track all the data through the Department of Justice as far as whether doing this tool and using this as a decision-making guide would help us decrease our failure to appear rate and decrease our new criminal activity while people are out on bond. And once the research is complete, we would then, if it looks to be an effective tool for the state of Wisconsin, we would look at helping move the tool out statewide for other counties to begin using the tool as well. So the Department of Justice actually, I applied for a grant through them to get a position over at Attic Correctional Services for a full-time pretrial assessor. And that position actually started last October. And she began assessing every individual that was held in custody awaiting their initial appearance. She did the PSA assessment and she tracked data for 5 months. The reason we did all that tracking is because this has proven to be the most complicated program I've ever tried to implement. And I've been doing this for about 25 years. And the reason is that I'm not only trying to guess how many people are going to come through the system and need these services, I'm trying to guess what level of services they're going to need and what level of services supervision they're going to need, because that, in the handout that I put in there, you can see that I have it labeled level 1, 2, 3, and 4. Depending on how the person assesses on that PSA tool, that determines how much time they get in service from the case manager. So we had 5 months of data, and things were looking like we would need 3 full-time case managers to supervise individuals pre-trial who were likely to be released, dependent on their level of data that we had collected, and matching the state guidelines of the type of supervision they'd like us to provide to each level. And I received a quote from our provider for $168,000 for those case managers that would be needed. We currently have a half-time case manager and provide very limited condition of bond, basically drug testing when requested. So then COVID started, and it completely threw off our data, completely threw off our numbers. People being held for initial appearances dropped drastically. So we were seeing less people getting assessed, but they were some of the more higher risk individuals, and the cases that had come through were not closing. And so people's pretrial period was much longer. So obviously, if I'm on supervision for 3 months and now I'm on supervision for 9 months, and I'm a level 4, that's going to increase the amount of case management time as my caseload continues to build. So that became something that we had to try and navigate. I really wanted to have a good solid plan for case management and how many we needed, because these are positions. These are people that we would be hiring. We obviously don't want to hire people if we don't need the individuals, and we don't want to get in a position where some of the other counties are at right now, where people are being ordered to supervision and they don't have case managers available. So they're literally on a wait list for supervision, but yet they're out. So it's been very difficult to figure that out. The other thing that happened during this time frame is the Arnold Ventures, as they now call the Arnold Foundation, came out with a recommendation saying that they no longer agree with the bump ups that were used by some of the other areas around the country. And when I say bump up, what I mean is there were a list of offenses that if somebody was charged with that offense, they automatically bumped to a level 4, regardless of the other circumstances and history that's accounted for in the tool. So what Arnold Ventures said is, we really want that to be the judge deciding that. Just because the charge is one thing, that shouldn't dictate an automatic level 4. It obviously plays into the decision, but that's something for the prosecutor to argue. And so this tool, they wanted to stay genuine to the research. So they wanted to be able to present what they call a raw score. So our planning group went back to the drawing board, had discussions with people in our local communities, and decided that we wanted to stay true to the research and the foundation's recommendations. And so during COVID confusion, the bump ups were also dropped, which also skewed our data again. So that leads me to where we're at today. That was history. Where we're at today is we started October 19th on what is called a soft launch. And a soft launch is where our assessor is doing all of the work, doing all of the background checks, creating all the reports, circulating them within the system to everybody who's supposed to receive them. And you notice I said supposed to receive them because we've had some bumps. It's been challenging with the technology and people not in the offices. And we had our first month of data tracking, and you can see this pretrial PSA recommendation projections. These are some of the things that our planning group wanted tracked. They wanted information on. We're also going to be, as we move further out and get past our first month of data, we're going to start tracking failure to appear because, of course, as I mentioned, that's the other major area that we want to pay attention to. Of course, with 1 month of data, there's not a lot of time to fail to appear because the hearings are set out. So we are going to add that on. So you can see that in about 1 month, they did 59 assessments. You can see what levels the individuals fell under. You can see how many of them were actually released, what percentage depending on level. Male and female, significantly more males. The age range, the reason it's broke out like that is because being young automatically increases your risk. So we want to keep an eye on that and make sure that's not skewing things, but you can see that our higher risks don't have a lot of young people. I think that also shows that the other parts of the system are doing a good job. If you have somebody youthful first time, they're not bringing them in and holding them for initial appearance. Some of the other counties that are working on this project actually hold a lot more people than we do for initial appearance. We've started to track new criminal activity. This is an interesting, so you can see that the PSA appears to be predicting pretty accurately because the majority of the new criminal activity has fallen under the level 4 individual, which you would expect. They're saying those are the people who are more likely to have criminal activity. The reason we're tracking probation, who's on probation, because we had some discussion when we got the dollar amount price tag for case managers. We had the discussion, do we need to supervise somebody who's also on probation supervision? Or do we hand off that supervision to the probation agent? Different counties are handling that differently. Some are doing dual supervision and some are not supervising probation people. So we have not made a decision. We're watching our data. We originally suspected that number was going to be a lot higher than that 30%, but that's not been the case. Out-of-state charges and the impact of those, we're watching that because the criminal background is something they want the national background check done, not just CCAP. And so that's part of the whole process that takes place in the morning before initial appearance, where the assessor is working with the district attorney's office and getting those backgrounds, making some calls out of state, verifying things. And we had guessed pre-COVID it was about 20% were impacted. And it's even less than that. It's almost 20% that have out-of-state records, but it's affecting about 13% of the time their score. So that is the data information. We're still working out a lot of process issues. You know, the process has to be done and to the judges and to the attorneys so that they have time to review them before 2 o'clock. So obviously, when there's a large number of people appearing, it gets kind of hairy. We're training some additional case managers to do backup. So on days there's large numbers, they can be moved through quickly. I think I guess if anybody has any questions right now, we're just trying to figure out how we can make this happen. And I know that the DOJ is still trying to apply for additional grants and things to help us out, but they haven't had much luck to this point. So do you want to add anything?
Yeah. Hello, everybody. This is Lance. Just, again, I think Laura made a point. You know, I think this agenda, you start to see how things build together in the justice system. In our last presentation that Jason's going to give in a little bit, demonstrates the need to talk about system budgeting. But to build on what Laura said, decision-making points in the criminal justice system. Ruth hit on a number of them in our use of evidence-based tools. The proxy being used by law enforcement on the street. Again, a way to supplement professional discretion, help individual decision makers do the best job they can. With deferred prosecutions in the DA's office, both at the pre-charge, the DPA, the deferred prosecution agreement stage, and the deferred entry of judgment stage. Ruth, Teresa, all of those staff are looking at, again, tools to assist them in making those decisions. We have a system-wide assessment that Marathon County has in place for a great number of years. This public safety assessment is that next step. This is that piece, the decision point, the very important decision point relative to bond. And all the work that Laura and her team are doing, if you want to think about what are the next steps that our evidence-based decision-making group is looking at, and we'll talk more about this in the last presentation today, we need to develop, essentially, if you're a private business, you'd call it a pro forma, right? Laura referenced the initial estimate we're doing based on the data that we have of $168,000 for the supervision component of this pretrial case management, which is assessment and supervision. That's the supervision component. So we need to know what resources do we need to bring to bear if we're going to do this. What resources do we need to have to do the assessment, which right now we have a grant that Laura applied for to do that assessment. But what do we need for the assessment and then the case follow-up, that supervision? And our hope, and Jason's going to talk about this in a little bit, is that we sit down as an evidence-based decision-making team or a stakeholder team within the criminal justice system, and we need to come up with a recommendation for all of you to consider on if we're going to do this. I mean, I think everyone recognizes we don't have endless resources. If we're going to do this, what resources is it going to take, and what are we going to do? What are we not going to do? Or what are we going to shift resources, reallocate from somewhere else to make this happen? And we still have a lot of work to do, but I thought it was important. This agenda really came together, and speaking with the chair and the vice chair, really came together nicely in terms of a couple of things that flow together. The criminal justice system in Marathon County has been very proactive and progressive in terms of looking at tools to, evidence-based tools and strategies to, first and foremost, enhance public safety. But as Teresa referenced, the benefit of those is that you do them right, you employ them, you should see cost savings, not only in the short term, but for sure in the long term. So that's where we're at right now. So the next step, again, is going to be continuing to get that data. You will see a pro forma from us at some point, because we're going to have to come back and build the budget for this program if our criminal justice stakeholders continue down this path of saying, hey, this is something we're really invested in. So with that little bit of additional background, I don't know if Laura, did I miss anything? Or if anybody has any questions, we'd be happy to answer those.
Well, thank you for that presentation, Laura. I guess a couple of questions. You know, we've got 4 different levels of supervision requirement depending on how the individual tests out. Do we have any, and obviously you probably do, a rough estimate as far as the amount of time and supervision requirements for each of the different levels for a case?
Yes, yes. That's something that we worked out among the coordinator group. And it's been actually tested out in other areas that La Crosse has got a significant start on this, Outagamie County as well. And so, yes, I didn't bring that all with me today, but that's how I calculated the staff time. Obviously, a level 1 gets nothing at all other than a text reminder, a court reminder. Once they hit level 2, then they get 1 time a month face-to-face supervision. They get the court reminders. And then level 3 is twice a month. Level 4 is every week face-to-face. And then we also have other things in there. Some of the recommendations from the Department of Justice is that GPS monitoring be made available, and we haven't even gone there yet. So depending on, you know, what the judge would like placed in the order, it obviously increases the amount of staff time.
Thank you.
Any further questions for either? All right, thank you. Yeah. So just so people are aware, the reason we're jumping all around is there's only one microphone that's not echoing, so. All right, and then we're to 6D. I'll just do a quick spin-off. So we kind of went down the gamut here of diversion. Per Supervisor Jacobson and myself at the budget meeting, we basically made an oath that we were gonna look at the criminal justice system as a whole because of some of the things brought forward by Teresa. Just some background for people that were not on the public safety, and I was not chair of public safety, nor was I even on public safety in my last term. I was actually the chair of Health and Human Services. When Craig McEwen, Vice Chair McEwen, was the chair of public safety, the direction we gave administration was the top priority was a dispatcher. With the ongoing things that we had at budgeting and other things, we're looking at that again. So, because the reality is, we think we need to look at it this whole with talking with Teresa. We're moving forward with the plan that we did spell out at the budget meeting. We've been in Lance and I had a brief meeting with Teresa. Lance and I have had a couple meetings, just calls, I guess, talking about it, and we're moving forward on this to basically sit down with all the parties for an overall view of the criminal justice system. And per our promise, we will have something in June. So with that being said, this is what I will turn it over to Lance, some of the beginning steps.
Thank you, Chair Boots. And I actually have, Jason is going to come up in just a minute, but just a bit of background, you know, this idea of system budgeting, it's a term that in administration, former Administrator Carter and I started talking about it, excuse me, in 2019 around the time of the budget. And if I'm being very honest with all of you, that's not a term that exists anywhere. It's a strategy that we came up with, and you know, it's an idea. And what you're going to see today is the kind of manifestation of additional conversations I've had with Jason, trying to rough out how we think this is going to work. Quite honestly, I think it's a really strong idea, and from a logical standpoint, you'll see the flow Jason has put together to lay out what we think the next steps are and what our goals are. But excuse me. You you know, the presentations you've seen up until today, up until this point today, really lay out why this is important. You know, our old way of budgeting just is not gonna solve the problems we have today. So we need to look at everything in a system fashion. That doesn't mean we stop looking at it in the way that you guys have done before, and I think Jason's gonna give you an overview of what we're thinking, but by no means are Jason and I the experts in this area. We're looking for feedback from you on this idea. We're gonna look for feedback from the stakeholders when Jason and I sit down and meet. I think I've mentioned this to this group before. I had a really great conversation at the end of, I should say just 2 months ago perhaps, with Teresa, with Clerk of Court, Shirley Lang, and with Sheriff Parks. Again, talking high-level concepts. I think we're onto something here, but this isn't a roadmap that, as far as Jason or I could tell, you know, we didn't find anybody that's doing this in a meaningful way as we looked around. That doesn't mean someone's not, and if you know of anyone, let us know. But you're gonna see our first attempt at this, and I'm gonna share my screen and ask Jason to come up here, because as again, Chair Boots indicated, we're having a little bit of technology issues with microphones, but Jason will walk you through the document that we put together, and we'll open it up for questions at the end.
All right, thank you. So, what we've done is we've talked about, you know, what is system budgeting, why is it important, but I think what we should also talk about is what does success look like. So on this document, what we have is various departments, what does success look like? And we think it is various departments working collaboratively to examine and develop county budgets with consideration given to systems rather than simply focusing on individual departments or countywide strategies. So incorporating meaningful and specific departmental, system, and countywide performance measures that are based on identified departmental, system, and countywide goals into individual employee performance and appraisals. So down below we have a graphic, and as you can see we have, you know, kind of out on their own performance appraisals, budget goals and priorities, and then evidence-based decision-making. And our attempt is to bring all of those in together under one system, which we've called system budgeting. And then a really useful tool that we think will help assist in this is our priority-based budgeting that we are working on refreshing right now. So down below, what we have here is what we have put together, a roadmap and a rough timeline on what we think will help start this process and get us moving in a productive manner. And like Lance stated, this isn't something that you know, we could just go out and find other counties doing. So this is intended to be a working document, and we can certainly make changes at any point through the process, but we wanted to get something down to start the process. So the first step would be engaging stakeholders. So let's identify who they are. Let's engage the stakeholders to explain the need for system budgeting. So what is it? Why is it important? Let's outline the goal that we wish to accomplish with this approach. So really, why are we here? What challenges are we looking to overcome? The next step would be, let's define the problem. Let's quantify it. Let's put some numbers and data behind the problem. Let's diagnose the conditions that are causing the problem. And then let's rank the problem. So what are the top priorities? What do we want to do and try to tackle first? The next step would be programs and services. We need to know what we are doing and really how well are we doing it. So let's identify all the relevant programs and services. And then let's set the standards by which the programs will be evaluated. So how are we going to measure the effectiveness of those programs? And I think a really useful tool that we can use to help with this step is priority-based budgeting. The next step would be setting the goals. So let's set realistic and attainable goals. Let's break down long-term goals into short-term goals if it's necessary. And then let's outline the goals within the county and department budgets and performance appraisals. So this will really allow everyone to get on the same page and create some accountability around those goals. The next step would be constructing alternatives. So let's make a list of all the alternatives. So really any idea that can help overcome our problems or help achieve our goals. And then let's conceptualize and simplify the list of alternatives. So let's kind of break those down into what we think are the most viable options. The next step would be let's confront the trade-offs and evaluate the alternatives. So let's start doing this based on the evidence and data that we have. And then let's try to narrow and deepen that analysis. Look at it from more than just the data, which kind of flows into the next bullet point of let's apply a holistic approach and rank the alternatives. Next, what we'd like to do is decide and then provide a recommendation to the policymakers if necessary, based on the analysis that we just did. And then what we need to do is we need to make sure that we decide on an alternative that has a champion in the relevant policy environment or who has an incentive to implement it and see it through. So it's always important to make sure that we have somebody that's going to follow through long-term to ensure the success of the decision. And then the next step would be communicate that decision. Let's communicate the decision and the expected outcomes to the relevant stakeholders and interested parties. Let's make sure everyone is on the same page. And again, I think this could be done through, if we go back to that first image I showed through the county budget goals and priorities and performance appraisals. And then the last step would be let's review the decision. Let's reconvene and evaluate the success of the decisions we made, and then make any necessary adjustments as needed. So again, I think this will help us start the process and assist us in making positive systematic changes. We do have a rough timeline that we put out here, but we definitely want to engage with the stakeholders and make sure that this timeline would work for them. What we have would be from start to finish, engaging stakeholders in December, and then concluding with a communicating what decision was made by May. So are there any questions? Sure.
This is Lance. I just have a couple things I want to add, and I think Jason did a great job of giving you that high-level overview. In terms of, excuse me, I need to drink more coffee. In terms of, adding a little bit of information, not to dive down into to really get into the numbers, but, I think this is an exciting prospect, and I want to show you that in a couple of ways. I think it's exciting because the good news, we already have groups that really, I think my assessment is they work well together. It's kind of like family, right? That doesn't mean you don't have squabbles and everybody gets along. We certainly have our share of competing priorities, but we have good discussions, and I think we have people at the table that are invested in finding solutions. And I just want to convey to you, we had a meeting yesterday, a case processing meeting of our evidence-based decision-making group, and I wish I would have recorded that WebEx or I think it was a Zoom meeting actually, but I recorded that meeting to show you, if we follow through on the things that came out of that meeting, it was two judges, Judges O'Neill and Judge Strasser, Teresa and Ruth, members of the Clerk of Courts, the defense bar with the Kat Jackin from the State Public Defender's Office. Really good conversations about problems that were coming up and barriers. And my perspective from participating in that was there are good solutions that came out of that meeting. And that's an important framework to have, because this is really the next step. When you have solutions, they generate savings, like Teresa talked about. You know, you look at the diversions, what those mean. That's work the DA's office is doing, and it's resulting in savings that are realized. There's certainly savings in the DA's office that prosecutors aren't having to walk a case through court, but a lot of savings are happening in the court system. They're happening in the jail. And, you know, we have members of those systems that are certainly invested from a culture standpoint, an ideology standpoint, but we want to make sure that we all share collectively in the benefits that are conferred by those process changes. And quite honestly, our current system of budgeting doesn't do it. As we wrote in the document that's on your screen, you know, really system budgeting in our mind as we're trying to come up with this, it doesn't mean you go away from a department budget or you completely jettison countywide priorities, but it's this system budgeting in our mind as we're trying to flush this out really exists in between those two things. So you do share quite honestly, you share the struggle. It incentivizes us all to work together to solve those problems, and then we share in the solution, the benefits of those solutions. So I think it's a framework. Do we have a lot of work to do? Absolutely. But just to add a little bit of flesh to the bones that is in the document on your screen, when you look at, Jason talked about defining the stakeholders. Who would we envision being at the table, this expert table? We have the sheriff's office, the district attorneys, clerk of court, the justice systems, and also we added nonprofits that deliver service, justice system related services. So when you add all those departments and entities together, what you end up with is about $27 million in tax levy, $31.5 million in terms of total budget of the county budget. So there's a lot of resources at the table between those departments, our justice system budget, and then nonprofits like JudiCare's mediation program, which the county board funded in 2020, in your 2020 budget, the Women's Community Housing Program, which you funded for some period of time. So all those things, there's a lot of opportunity to bring people to the table and have resources to solve the, quite honestly, immense needs we have across those departments, because the needs are many. You know, as Chair Boots said, and Teresa's on the line, the DA's office has significant needs, both at, with respect to prosecutors and with respect to office staff. The dispatcher need within the sheriff's office, need for additional law enforcement. The sheriff's office has had a recurring position request, and our court system is getting a new judge, and the only reason they didn't ask for positions is because I told them they weren't gonna get them before the position requests were in, so they saved the effort. So the needs are many, and I think this conversation is an important one. The little graphic at the bottom of that first page, I think that's important, and what we tried to convey there, as Jason said, is we see an opportunity really to integrate a number of things. It's again, budget goals and priorities. It really adds another level of opportunity in my mind for our evidence-based decision-making group. Because again, it adds, not only do we have people that are invested in terms of ideology, you know, everyone at that group wants better outcomes. But now it adds a financial component, a motivation that, quite honestly, we hadn't really been able to capture before. And then the last part there, which is a conversation that Jason and I had, when you look at performance appraisals, you know, I think there's a real opportunity to build that out and say every performance appraisal within a system should have not only an individual employee component of what are the goals and expectations I have for an individual employee, what are the goals and expectations I have for you by virtue of your work within this department. But then add another layer on that and say, what are the goals and deliverables we're looking for you? What would success look like? How would you know you're doing a good job from a system perspective into that performance appraisal? And that could be the same, or at least it would be similar for people in the sheriff's office, for individuals in the clerk of courts, the district attorney's office, justice system. So in effect, our hope is, and we don't have this flushed out, but our hope is we can get everyone kind of pulling in the same direction, right? It's the story you hear about Kennedy visiting the Space Center, right? And he asked the janitor, you know, what do you do here? And the janitor says, my job is to get a man on the moon. We want everybody to understand what are the goals of the system. Like Teresa talked about, having key performance measures or measures to how are we going to define success and how are we going to measure it. We want everyone in each of the departments within the system to understand what success looks like and see how their job can contribute to that. Because the reality is, you know, if I'm a judicial assistant in the court system, I contribute a ton to the success of the criminal justice system. When you talk about how quickly cases move through the justice system, like Teresa talked about and Laura talked about, things sometimes languishing, you know, they have a huge role. So how do we get everybody pulling in the same direction? So that's the idea with this systematic budgeting overview that you have. If you have questions or concerns or thoughts, please pass those along. And I've talked too much because I know we have another meeting in here at 4 o'clock. So, but I'd be happy to answer any questions you have after the meeting as well.
Any questions for Lance at this point?
Supervisor Bizzotto?
Go ahead.
Yeah, I'm sorry. Lance, both you and Jason referenced something that's on the screen, and I'm on the phone. If it's in the packet, and if it is, if you can point it out for me, and if it's not, if you can maybe send it out afterward.
Perfect. I had that note on and thank you for reminding me. It didn't make its way in the packet. We'll add it to the packet, and we will email it to committee members as well.
Great, and I just wanted to thank you both for raising this. This is really exciting, and I hope you keep us all updated because I'd love to help.
I have 3 notes that we need to approve the minutes. 3. So we should do that. Can I get a motion to approve the minutes?
Ms. Mask, move to approve.
Okay, motion made. Do I have a second?
Supervisor Bizzotto?
Motion made, second. All in favor? Aye.
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 Any opposed? Motion carried. Again, I'd like to thank Lance. Again, this is going to be on our agenda monthly. We're going to have it until obviously June. And both Supervisor Jacobson and myself will be integral parts dealing with Lance and the rest of the criminal justice system and giving you updates as part of the implementation of the what we spelled out at the budget meeting. With that, any further questions? Go ahead.
I guess I just wanted to have a couple of comments. First, I want to thank Administration, Lance, and Jason for taking the lead on this effort. You know, we talked about it over a year ago, but I also want to thank the department heads for stepping up and participating, because clearly their participation and is all that it's going to be required to be successful. But there's also a challenge here, and that challenge is to the county board. And that county board is going to have to take ownership and education in the priority-based budgeting system that we have and the upgrades that we're going to be making. So stay tuned. And again, I just want to thank everyone for all their involvement in this new endeavor that will now coin system budgeting. So thank you, everyone.
All right, with that, any further questions on 6D? All right, if not, committee members are asked to bring ideas for future discussion. Our next meeting is Wednesday, January 6th, 2021 at 2 o'clock. If anyone has any issues with that, please either email me or Lance. And I will take number 8.
Motion adjourned. Aye.
Motion to adjourn, do I have a second?
Second from Supervisor Bozota.
We have a motion and a second, all in favor?
Aye.
Any opposed? Motion carried, thank you very much.